Hello and welcome to Jumbo IS and welcome to lecture number 2 of this lecture series called Prelims Powerplay 2026. Now look, I want to say something really important. All those of you who are following this lecture series properly, well, you need to be more disciplined about it. Because I've seen this, most UPSC aspirants who are following this lecture series, well, they are just watching the lecture and not revising it from the notes. Okay, let me tell this to you. If you follow this lecture series properly, watching this lecture, then revising it and memorizing it from the notes and then giving the test on time. If you do this till the end of your prelims examination or till the time of your prelims examination, well, the thing is, you don't have to, and let me repeat this, you don't have to follow any monthly current affairs magazine or any PT 365, anything. All your current affairs would be covered through this lecture series only and through these notes only. Plus, not just current affairs, all the other important topics would be covered through this lecture series, through this program, Prelims Powerplay. Okay? But you'll be ready for your prelims examination only if you follow this program properly. Watch the lecture, revise and memorize the notes from the lecture, then give the tests on time. Okay? Every 10th day, there will be a test. Be consistent with it. And one more thing. Every day, this lecture would be uploaded at 9 p.m. Watch this lecture on 9 p.m. at 9 p.m. Okay, be time bound also, because if you'll be disciplined, properly disciplined, I'm not demanding anything else, I'm just demanding 1 hour of your day. But if you'll be properly disciplined, well, everything that you require for your GS prelims would be covered in this lecture series. Okay, by the way, after the lecture, if you have any doubts, you are in these WhatsApp groups, ask those doubts over there. Those WhatsApp groups are for your doubts only. Clear? And all these new aspirants who are watching this lecture for the first time, well, to register for this program, Prelims Powerplay program, well, the registration details are given in the comment section below. Okay? And if you're finding any difficulty for registering for this course, well, there is a number also given in the comment section. Just WhatsApp that you want to register for this course and we will take it forward from there. Okay? Just WhatsApp us that you want to register and we will guide you how to register. But the registration details are given below, so you can automatically register also. And once you register, be regular and consistent. Okay? That's the introduction. That's the announcement I wanted to convey to you guys. Okay? Be disciplined. Only then this series would be useful. All right. Now let's begin lecture number 2, Prelims Powerplay. And as you all know, we are continuing with Polity. Now in the previous lecture, we talked about Tamil Nadu governor and Tamil Nadu government case. Okay? And Supreme Court basically gave a judgment. Today's lecture is somehow related to the previous lecture also. Okay, so if you haven't watched lecture number 1, in which we talk about that case, please do watch that lecture first and then watch this lecture. Okay, now you all know what happened in that case. The Supreme Court gave its verdict and the Supreme Court ruled in favor of Tamil Nadu government and against Tamil Nadu governor. Now, this really made Tamil Nadu governor and the central government, well, pissed. If I can use a mild word, okay? They were not happy with this. Therefore, using their powers under Article 143, the President of India made a presidential reference to the Supreme Court, questioning the judgment Supreme Court gave in this Tamil Nadu case. Okay? Now, what is Article 143? Under Article 143, well, the President of India can seek legal advisory opinion of the Supreme Court. And using this 143, well, the President of India, President Draupadi Murmu ji, she currently referenced this Tamil Nadu case judgment to the Supreme Court, questioning its validity. Clear? So what is important for us? Today we are going to focus on Article 143. What is this presidential reference? What is written in the Constitution? And what are the legal provisions related to that? Okay? So today's topic of discussion is presidential reference, Article 143. And in the end, I will also talk about, well, the current case. What questions were asked by President Draupadi Murmu to the Supreme Court and what is Supreme Court's answer? Okay, what is the current situation? I'll talk about that in the end. But first, we'll focus on what is presidential reference, Article 143. Okay, so let's begin. Presidential reference, Article 143. Okay, so presidential reference, Article 143, Polity, Lecture 2. Okay, so long story cut short. Well, presidential reference or Article 143 means that the President of India has the power to seek legal opinion of the Supreme Court. Okay, Supreme Court's legal opinion can be sought before taking any action. Clear? This is basically the bottom line. Okay, if you can summarize Article 143 in one line, this is that one line. Okay, President of India can seek the legal opinion of the Supreme Court. Clear? Now let's delve a little deeper into this. Okay, so what is Article 143? Basically, Article 143 is also known as the advisory jurisdiction of the Supreme Court. Why is it called advisory jurisdiction? Because under this, Supreme Court can provide its advice to the President on the question asked by the President. Okay, that is why we call it advisory jurisdiction. If you have studied polity and you have studied Supreme Court, you know that Supreme Court has various jurisdictions: original jurisdiction, appellate jurisdiction, writ jurisdiction. This is advisory jurisdiction. Clear? Now, this grants President the authority to seek legal opinion from the Supreme Court. All right. Now, this article has two clauses. Okay, so it is Article 143, Clause 1, and then Clause 2. Now, what is written in the first clause? So, Clause 1 says that the President can refer a question of public importance. Okay, any legal question of public importance, general public importance, anything concerning a point of law, interpretation of the Constitution, or any fact from the Supreme Court. So basically, Clause 1 is open-ended. President can ask legal opinion on anything and everything under the sun from the Supreme Court under Clause 1. Okay, then what is Clause 2? You know, before our Constitution came into being, well, there were various treaties, agreements, laws that existed even before our Constitution, and they are still valid. Now, when the President will ask a question with respect to this pre-constitutional treaty, agreement, covenant, contract, any pre-constitutional, British time law, agreement, contract, when a question would be asked with respect to these things, this would come under Clause 2. Okay, so there are only two clauses to this. Simple. Clause 1, open-ended, anything. Clause 2, only with respect to pre-constitutional agreements, treaties, covenants, everything. Clear? Now, just remember this, okay? If President asks the question with respect to Clause 1, well, it is non-binding for the Supreme Court to give its opinion. Supreme Court can even decline its opinion. Supreme Court can even say, I'm not giving opinion on this. Supreme Court can basically decline. Supreme Court can choose to give its opinion or choose to deny giving its opinion. It is up to the Supreme Court when it comes to questions asked under Clause 1, like the current question, okay? When it comes to Clause 2, when President asks Supreme Court's legal opinion with respect to Clause 2, then the Supreme Court has to give its opinion. It is binding on the Supreme Court. This is what the Constitution says. Clear? Now the thing is, remember, Article 143 is known as advisory jurisdiction. That means the Supreme Court will give its advice on a legal question. Now, if you analyze the English word advice, well, advice is advice. It is not binding on you. If you are seeking someone's advice, let's suppose you are asking your friend for an advice. Well, that's just advice. You can choose to follow it or not follow it. Therefore, all legal opinions given by Supreme Court under advisory jurisdiction are non-binding. They are just advisory. They are non-binding on the President. The President can choose to ignore them. Okay? But because this opinion is given by the highest court of the land, okay, it is given by Supreme Court. Therefore, it carries a lot of legal weight. And that is why presidents rarely ignore it, because it carries a lot of legal weight. Supreme Court is giving this opinion, okay? But technically speaking, legally speaking, it's just an advice, non-binding in nature. But generally, presidents follow this advice. You understand this point, okay? Now, let's talk a bit more about this. So Article 143, some key facts. Okay, number one, whenever President will ask any legal question to the Supreme Court under Article 143, well, first, Supreme Court will make a constitutional bench. Okay, Supreme Court will form a constitutional bench, and in this constitutional bench, there will be minimum 5 judges. Basically, you need to know this about constitutional benches. Whenever you hear the term constitutional bench, that means that the Supreme Court has formed a bench of judges for interpreting the Constitution. Okay? And this constitutional bench will always have minimum, it can have more also, but minimum 5 judges. Clear? So a constitutional bench is generally formed when Supreme Court has to hear any case with respect to the constitution, and it should have minimum 5 judges. Now, whenever president will ask a legal opinion under Article 143, Supreme Court has to form a constitutional bench, and this constitutional bench will decide and give its legal opinion. So minimum 5 judges will give their legal opinion, and this is mandated under Article 145 clause 3. Clear? Now, this is fact number 1. Remember this. The concept of advisory jurisdiction. Okay, where did this concept originate? Where did our constitution makers borrow this concept from? So basically, when we were being ruled under the British system, okay, when we were ruled by the British, well, India was ruled by a governor general. And the highest court of the land was not technically highest, but the level of Supreme Court, okay? It was the federal court. This federal court was re-christened into Supreme Court after independence, okay? So during British rule, the role of the president was performed by Governor General of India, and the role of Supreme Court was performed by Federal Court of India, okay? Now, as per section 213 of Government of India Act 1935, okay, the Governor General of India can seek legal opinion of the Federal Court, and that was the advisory jurisdiction of Federal Court. We have copied this provision in its entirety from Government of India Act. So if there is an MCQ, advisory jurisdiction of the Supreme Court is inspired from which law or which constitution? Just write Government of India Act 1935. Okay, remember this fact number 2. All right, make sense? Okay. Now this is all you need to know as far as, well, the details about presidential reference or Article 143 is concerned. Okay. Now, there are some advantages to this Article 143 and there are some criticisms as well. Some people criticize this provision of the Constitution. Some people have mentioned benefits. Okay, they say that this is beneficial. So we will try to analyze both advantages and criticisms of presidential reference or Article 143. So first, let's talk about the significance. Okay, it's very important. Remember this. So significance of Article 143. First of all, well, generally presidential reference is made before taking any action. So when the government is thinking about taking any action and government feels that there can be a legal controversy, that some people might in future question this action by the president or the prime minister legally. Okay, so before taking that action, well, the Supreme Court's legal opinion is asked. So when the president is going to take some controversial action, before taking that action, he can seek the legal opinion of the Supreme Court so that in future, there are no legal controversies or conflicts. So advantage number 1 is it prevents future legal conflicts. You take this opinion of the Supreme Court beforehand. Okay, then there won't be any question. No one would challenge this action in the Supreme Court because you have already taken Supreme Court's opinion. So it prevents future legal conflicts. Then number 2, it aids constitutional interpretation, vital for good governance. Governance of India should be by the principles of the Constitution. Now, when the principles of the Constitution are in question, well, you can seek Supreme Court's legal opinion so that every action taken by the government is by the principles of the Constitution. So this is advantage number 2. Advantage number 3. Well, it keeps executive actions within constitutional limits. Okay. And today I'm going to teach you a keyword which you can use in your answers and an MCQ can be asked. Okay. This keyword is ex ante legality. Now, what is ex ante legality? There are 2 words, ex post legality, ex ante. Okay. Now, ex post means that when the government takes any action and people are not happy with it, they think it is not legally permissible. So they challenge that action in the Supreme Court or High Court. Okay. Now, this is an example of ex post. Why? Because after the action has been taken, then you are challenging it. When the action has already taken place, then you are challenging it. This is ex post. That means afterwards. But if you can test the legality of an action before taking that action, that is ex ante legality, beforehand. So using this presidential reference, well, the government can exercise ex ante legality. Okay, checking the legal sanctity of that action beforehand and then take that action. Okay, so remember this keyword. Clear? So this is there. And last, well, there are many federal disputes between center and states. Okay, they can be questioned or a legal opinion can be sought on these federal disputes by the president beforehand. So it handles federal disputes also, center-state tensions also. So these are some of the advantages. Now, some people criticize Article 143 as well. Okay, so what are these criticisms? Let's talk about this. Okay, so criticisms. Number one, first of all, it's non-binding in nature. Okay, president is not forced to follow this advice. So some people say, then what's the use of this advice? If it is non-binding, then why is even Supreme Court giving its opinion? Okay, so this is criticism number one. But we already know that still the advice carries a lot of weight. So it is important. Yet this is the criticism. Then the next criticism is risk of politicization. You see, generally governments are afraid of taking politically controversial decisions. So what they'll do is, before taking those politically controversial decisions, they would seek the legal opinion of the Supreme Court. If Supreme Court validates the legality, then they will take that political action. And when people would criticize the government, they would say, look, Supreme Court is with us, so you can't question us. So, well, there is risk of politicization. This is another criticism, though not that valid, but it is still a criticism. Then third is, there is no timeline for response. There is no timeline for the Supreme Court to give its opinion. No timeline. Supreme Court can take 1 year, 2 years, 10 years or forever. There is no timeline mentioned in the Constitution. So this basically is a criticism. And number four, already Supreme Court is burdened with a lot of cases. High courts are burdened with a lot of cases. This adds extra judicial burden on the Supreme Court. Clear? So these are some criticisms. Now, one more thing before we end this presidential reference. Okay. In the past, President of India has made various presidential references to the Supreme Court. Okay. Now let's discuss some examples of those presidential references. Okay. What presidential references were made in the past? Some landmark cases. So let's just discuss them. Okay. So we'll discuss them briefly. Okay. So the first one is Keshav Singh case. Basically, the case was that, well, Keshav Singh criticized a local MLA MP. And well, the House, the legislature thought this to be breach of privilege of MLAs. So they arrested him. So he said that this is a breach of my fundamental right. Now the question was, well, the privileges of a House or fundamental rights, which is superior? The court said that fundamental rights are superior. Nonetheless, you don't have to delve that deep into this question. Okay, just remember this was the first case and it was all about, well, balance between privileges of legislature, okay, Lok Sabha privileges or House privileges and fundamental rights of an individual. Then the second is Berubari Union case. Okay, Article 3 of the Constitution allows the government or parliament to change the map of India, divide two states, combine two states, okay, change the map of India. And for that, they do not have to do any constitutional amendment. By a simple law, they can redraw the internal map of India. Now, well, now Bangladesh, but before 1971, it was called East Pakistan, right? Now, there was this international agreement between Nehru and, someone from Pakistan. And there was some territory which was with India. We had to give back that territory to East Pakistan. Okay, that was Berubari enclaves. Basically, the President of India sought the legal opinion of the Supreme Court that can we give this territory to Bangladesh or East Pakistan under Article 3 without constitutional amendment, or should we do constitutional amendment? The Supreme Court said you have to do constitutional amendment. Okay, so this was Berubari Union case, very famous case. Then the Ram Janmabhoomi case, Ram Mandir Babri Masjid case. Okay, the Supreme Court, remember, this case came under clause 1. Okay, so Supreme Court was not bound to give its opinion. So Supreme Court declined its opinion. Then the third judges cases. This third judges cases was related to how the judges of Supreme Court and High Court would be appointed. So a presidential reference was made and Supreme Court gave its judgment, opinion. And in that opinion, the collegium system that we now know was formed. And the last was 2G spectrum case. Okay, again, in this case, the question was asked how natural resources of the country shall be distributed. That's all you need to know. And the latest one is, well, the Tamil Nadu governor case. All right. Now, the Tamil Nadu governor case is currently pending. A 5-judge bench, constitutional bench, is currently hearing that case. Clear? Make sense? So these are some of the past usages of Article 143. Now, Article 143 is done. Now let's talk about the current case, the Tamil Nadu governor case. What is happening now? Okay, so the current case. So President Draupadi Murmu made a presidential reference to the Supreme Court of India in May 2025, just after the Supreme Court judgment in Tamil Nadu versus Governor of Tamil Nadu case, where the Supreme Court ruled in favor of Tamil Nadu government, not the governor. So the governor R.N. Ravi and the central government of India were not happy with this judgment, and Tamil Nadu state government was happy with this judgment. So the central government made this presidential reference under Article 143 to the Supreme Court, questioning this judgment of the Supreme Court. Okay, whether this judgment is legally valid or not. So this question was posed to the Supreme Court for its advisory opinion. Make sense? The legality of this Supreme Court judgment was questioned under Article 143. Now, a 5-judge constitutional bench of Supreme Court led by Chief Justice B.R. Gavai is currently hearing the presidential reference. Now, what was mentioned in this presidential reference? Okay. So, under this presidential reference, well, the President of India posed 14 questions to the Supreme Court. We need not remember these 14 questions, okay? Just remember 3 important questions that were asked by the President to the Supreme Court, okay? Now, as you remember, if you remember the previous lecture in which I discussed what was this entire issue was. So, remember that and now understand these 3 questions, okay? So, question number 1 was whether the Supreme Court had the authority to prescribe timelines for constitutional functionaries to act on bills. The Supreme Court gave a timeline for governor, right? So does Supreme Court has the authority? This is question number 1. Question number 2, whether the judiciary's imposition of deemed assent violated the constitutional separation of powers. You remember in that judgment, the governor was not giving his assent to 10 bills. The Supreme Court said that we are assuming that you have given this assent and we are passing this bill. The Supreme Court used its extraordinary powers under Article 142. Remember this, right? So whether this is legally valid or not, whether this deemed assent is valid or not, this is asked by Supreme Court. And the third, whether the actions of the governor and president regarding assent were subject to judicial review. The Supreme Court said that it is subject to judicial review, while the president is questioning this as well. Clear? So these are the 3 important questions out of these 14 questions that are being asked by the president under Article 143 to the Honorable Supreme Court. Clear? And with that, we finish today's lecture. By the way, I have also created the mind map of today's lecture. Okay, it looks like this. Okay, so this is the mind map. It will help you to quickly revise this topic. I'm going to share this in your app also. Okay, I'm going to share this in the WhatsApp groups as well. This mind map for your quick revision of this particular topic. Okay, so just check this out as well. All right, and that would be all. With that, we conclude today's session. So I hope you understood everything. By the way, if you have any doubts, ask those questions in the WhatsApp groups. Okay, but I hope everything was clear and it is adding value to your preparation. Remember, be consistent and regular with this lecture series. Follow it properly with discipline, and you shall, well, pass this exam, UPSC Prelims exam, with flying colors. You wouldn't have to worry about the result. And just after giving the exam, you would start preparation for mains. Okay? But if you are disciplined with this. So in the hope that you will be disciplined, I'm going to sign off for today's lecture with the promise of seeing you again with another topic in the next lecture. All right? Thank you, everyone.